Viewers, welcome back to the show. We've got a lot of questions from viewers in relation to workers' compensation and WorkSafe. But there's one question on point from a fellow by the name of Steve from Dandenong. Dave, do you want to tell me what the question is?
Thanks, Tony. Steve's question from Dandenong is basically he's gone to a solicitor and he's had a foot injury. He's been granted a serious injury certificate, so he's accessed the gateway. But since his foot injury has developed psychiatric consequences, he's become depressed. A CAT team's been called, and he's wanting to know, can he get compensation for that, given the certificate's only for his foot injury, Tony?
So the certificate's just for the foot, John. What's the, based on Georgopoulos?
Well, based on Georgopoulos, Tony, in the court proceedings, the lawyer should be claiming not only the foot, but the psychological condition and any other condition he might suffer from now. Literally, the serious injury certificate opens up the gateway, allows the worker to sue the employer or any other third party for all physical and psychological injuries he sustained.
It's a bit surprising, Dave, that Steve's lawyers don't know about this case, because I mean it's been splattered all over it's around the legal traps, isn't it?
It's a watermark decision in the last 20 years, Tony, so it is a bit surprising that the lawyer's not onto it. So,
Steve, see a lawyer, amend the statement of claim to include your psychiatric injuries. That way you'll get compensated for all your injuries. Now, let's move on, viewers. There's a couple more full court decisions we want to talk about. Dave, you've got an interesting one for us. Fire away.
Viewers, there's a case called Hayden Engineering and McKinnon, and in that case, Mr. McKinnon was a 62-year-old rigger employed by McKinnon Engineering. And what happened was, whilst he was working on a handrail on a platform, there was a hole on the platform itself and he fell through and injured his ankle. As a result of injuring his ankle, he suffered a fracture and he had metal plates and screws inserted into it. He worked on light duties for Hayden Engineering for a period of time, and then eventually his employment was made redundant from that employment. He went up to Euroa, where he was a handyman on a horse stud. He worked for a period of time and essentially continued to suffer problems with, he'd get tired at the end of a work day, problems with supporting his ankle and so on. So basically all he took was Panadol, Panadine Forte, so he wasn't taking a great deal of medication. You could probably say he was what was called a stoic worker, who was putting up with his pain.
David, what was Mr. McKinnon's claim?
Mr. McKinnon lodged a serious injury application in the county court. It was granted for pain and suffering, so that's effects on his lifestyle and activities of daily living. It was appealed and it went to the Supreme Court, where it looked at pain and suffering and consequences when you suffer an injury and whether they're serious or not. Justice Maxwell looked at the disabling effect of pain, he looked at the experience of pain and a whole lot of factors in terms of activities of daily living, how it affects your sleep, sex life, recreational activities, your hobbies you might have done prior to the injury, what your consequences are after your injury, and how it affects you generally. And one thing that was focused on in that particular judgment was sleep, and if your injury and the pain is having a big effect on your sleep and you wake up all night sort of thing, that could be a serious consequence.
David, what happened in that case?
In that case, the Supreme Court confirmed the finding of the county court, and the worker was granted leave for pain and suffering damages.
Okay. Now, in that case, sorry Tony, in that case, Justice Maxwell has basically given a form of a blueprint of what is required to prove serious consequences. Okay. Now, at the same time, His Honour did say this is not simply a checklist that you need to tick off on. It depends on the particular context of the worker, his particular circumstances, and the way the injury affects the worker and the impairment that he suffers.
But let's be realistic, okay? People go looking for consequences that sometimes don't exist. I mean, we've got a lot of labourers and people that get up at 5 in the morning, they get home at 7 o'clock at night, they get home, they watch TV, right? Where's your consequences there? Isn't the major consequence that most of these workers suffer the medication and treatment they get post their injury?
Exactly, Tony. It depends, again, it depends on what the worker is suffering. There's medication involved, there's lifestyle changes involved. Literally, sometimes the worker can't walk properly anymore. So it really, again, goes down to the particular facts to the individual. Now, and that's part of the whole serious injury application process, viewers. You need to show that you suffer from serious consequences as a result of your work injury. If you can't do that, you will fail in your claim.
And David, you come across a lot of people like I do that say, I don't want to take this medication because I want to put up with this pain. I don't want to do that because I'm stoic. I mean, bottom line, they don't help their cause, do they? Because, you know, like I said, you've got to be able to show a change that's significant to you.
Yes, Tony, you've got to be able to show that you've had consequences which have come from your injury which are serious. So, as John's correctly said, you've got to look at the treatment, what medication is being taken, any surgery that a person might have had, other treatment, you know, physio, chiropractic, things like that, how it's affecting their sleep and their day-to-day life.
Tony,
it's going to be serious.
Tony, how do you think Georgopoulos will affect the profession now?
Oh, I think it's going to help in the sense that it gives a bit of clarity. You know what I mean? It gives clarity in terms of what a plaintiff can get.
Now, I understand WorkCover weren't too happy with this.
No, they're not happy at all. But at the end of the day, the reason why WorkCover weren't happy was because if you could limit the injury to that injury that you've claimed, effectively what it means is that the payouts would probably reduce by at least 40 to 50%. But I think it's a bit of a short-sighted approach because lawyers would have told their clients to lodge more than one application. So it would have blown out costs and probably would have been a lot more expensive long term.
Exactly. So the reverse is that basically there could have been multiple applications.
Oh, of course. Just quickly, I want to get on to this other case and it'll be very, very brief. Crystal Brink and Nationwide Maintenance is a decision of His Honour, Mr. Justice Forrest of the Supreme Court, where he said that the work is not confined to those little facts you put in your affidavit. Do you want to elaborate on that, Dave?
Tony and viewers, essentially what the case was about is whether you could expand your what's called pleadings in the statement of claim to include injuries suffered over an entire period of employment as compared to specific dates of injuries. So that was what it was all about.
Now,
in this case, John, you counted one day.
In that case, WorkCover wanted to confine the worker to a short period of time. Whereas,
one day, John.
Exactly. And whereas the worker's employment was over a period of years.
Of course. And the thing is, if you confine it to that one incident, chances of proving negligence are probably a lot more remote than the whole employment. Because it was very heavy work over the course of his employment.
Exactly.
Viewers, it's come to the end of the show. We want to thank you for watching. I want to thank David as a special guest. Thank you, David.
Thanks, Tony.
John, a regular guest.
Thank you, Tony. Thank you, viewers.
And viewers, stay tuned for further episodes and please stay safe.